Ich begrüße Sie alle recht herzlich hier in der Universität in Präsenz seit langer Zeit nach Corona. Einmal wieder unser Law After Lunch hier in unserem angestammten Raum. Ich begrüße aber Sie auch alle recht herzlich, die Sie online auf YouTube dabei sind. Vielleicht ganz kurz, weil es passt. Wir haben uns entschieden, jedenfalls die nächsten Male das in dieser hybriden Form weiterzumachen. Das heißt, es wird die Möglichkeit bestehen, hier beieinander zu sein, was ich für wichtig erachte, damit man auch mal Gesichter sieht und sich persönlich austauschen kann. Wir aber auch für alle anderen, deutschlandweit, europäisch, international, unseren Law After Lunch Vorträgen online zu folgen. Und außerdem werden diese Vorträge, das ist ein weiterer Vorteil, dann abrufbar sein auf dem berühmten und bekannten YouTube-Kanal des Instituts für Wirtschaftsrecht über viele Jahre hinweg. So viel zum Technischen. Wir haben heute einen Vortrag von Dr. Andrej Lang zur Ombusperson im Rahmen des Sanktionsregimes des Sicherheitsrates der Vereinten Nationen, sehr verkürzt gesagt. Ich darf Ihnen Herrn Lang, soweit noch nicht bekannt, ganz kurz vorstellen. Er ist Habilitant, wissenschaftlicher Mitarbeiter am Lehrstuhl für öffentliches Recht, Europarecht und internationales Wirtschaftsrecht und das im Augenblick mit einer Finanzierung der eigenen Stelle durch die Deutsche Forschungsgemeinschaft. Herr Lang hat studiert an der Freien Universität in Berlin und in Paris. Nach dem ersten Examen ist er dann an die New York University Law School gegangen, hat einen LLM gemacht und ist dann ein wenig in New York hängen geblieben, wenn ich das so sagen darf, hat einige Jahre als sogenannter Litigation Associate, also als Anwalt, mitgearbeitet in einer Großkanzlei. Es folgte ein Forschungsaufenthalt in Harvard, an der Harvard Law School und dann eine Tätigkeit als wissenschaftlicher Mitarbeiter bei Kollegen Möllers an der Humboldt-Universität, zweites Staatsexamen, dann Arbeit an der Dissertation und dann seit 2014, wenn ich es richtig sehe, bei uns am Lehrstuhl tätig als wissenschaftlicher Mitarbeiter, zunächst auf einer Haushaltsstelle und jetzt seit einiger Zeit eben gefördert von der DFG. Das letzte Jahr hat Herr Lang nicht bei uns verbracht, sondern wiederum in New York mit einem Stipendium des DAAD als Research Fellow an der New York University Law School und im Rahmen des Gastaufenthaltes dort ist auch dieses Thema, dieser Beitrag entstanden, der, ich denke, Herr Lang, das darf ich sagen, sehr prominent demnächst auch nachzulesen sein wird, nämlich im American Journal of International Law, also eine herausragende Auszeichnung ist, dort veröffentlichen zu können. Das gelingt nur wenigen, zumal aus dem deutschsprachigen Raum. Insofern ein spannendes Thema, das andere schon für gut befunden haben, für herausragend gut sogar. Und wir haben die Ehre und das Privileg, das mündlich heute vorgetragen zu bekommen. Herr Lang, Sie haben das Wort.
Thank you, Professor Tietje, for the kind introduction. Welcome, all of you, and thanks for listening to my presentation. Since the article on which this presentation is based was written in English, I also had discussions in New York already on this paper, so I decided that it's probably best to do the presentation in English, but feel free during the Q&A round to ask questions in German if you feel more comfortable. It is a bedrock assumption of many international legal scholars that courts are institutionally best suited to protect the international rule of law and human rights, and that quasi and non-judicial alternatives are less desirable, if not insufficient or even harmful. The end of the Cold War sparked a stunning proliferation of international courts, but today the appetite for states for establishing international judiciaries has largely disappeared, and backlash against ICs international courts has become a recurring concern. The tectonic shift in the geopolitical context, with the American empire and the rule of the West fading, and a multipolar world order with China as a new superpower emerging, has likely ended the temporary golden age of ICs. Tom Ginsburg has even predicted in the American Journal of International Law that with the rise of authoritarian regimes, we should expect international law to increasingly take on the character of that demanded by authoritarians, which likely means less third-party dispute resolution mechanisms in the form of courts. At the same time, global governance still creates multiple accountability and human rights lacunas that require oversight or even an effective remedy. States seeking to provide oversight mechanisms and individual remedies at the international level are likely to opt for less intrusive and more flexible quasi or non-judicial review mechanisms. One of the most important manifestations of this phenomenon is what I call international complaint mechanisms. Examples are the inspection panel and the compliance advisor ombudsman of the World Bank, the International Labour Organization's Committee on Freedom of Association, the Aarhus Convention Compliance Committee, the UN treaty bodies, and the former ombudspersons of the UN transitional authorities in Kosovo and East Timor. I use a three-part working definition of these bodies, these ICMs. First, an ICM is a subsidiary organ of an international organization composed of independent experts vested with compulsory jurisdiction who conduct legal review to assess compliance with international norms. Second, an ICM serves as a triadic dispute resolver between individuals, communities, and/or NGOs adversely affected by alleged non-compliance on one side and the responsible state or international organization on the other side. In this triad, the former, the individuals, are entitled to unidirectionally file complaints against states or international organizations before the international complaint mechanism. Third, the mandate of the ICM is institutionally highly constrained. One of the motivations for states to establish ICMs is the expectation that these softer and more constrained arrangements succeed in cabining the institutional dynamics of independent quasi or non-judicial agents. Of course, the resulting institutional limitations of ICMs cost a certain normative price. To name only a few: shortcomings in the institutional guarantee of independence, procedural power imbalances between individuals and states or international institutions, and third, the legal capacity of political bodies to disregard the non-binding decisions of their independent reviewers. These are challenges that almost all ICMs grapple with in one way or another. This phenomenon therefore raises an important normative issue that is embedded in the broader debate about the just design of global institutions and reflects international law's inbuilt tension between realist pragmatism on the one hand and principled aspirations on the other hand. Do ICMs signify a welcome development in international dispute settlement that promotes the international rule of law, or do they represent a lamentable degradation of traditional judicial forms of adjudication? Are they a blueprint for global governance or a fig leaf for states unwilling to cede more control? I will not answer these questions directly in my presentation, but instead suggest the following more modest argument. How we normatively evaluate ICMs critically depends on their capacity to overcome at least some of their institutional constraints to better fulfill their normative missions, even if this does not conform to state preferences. In other words, it depends on whether ICMs can exploit the margins in their tight legal framework to provide an effective remedy for aggrieved complainants. Or again put differently, it depends on the institutional dynamics of ICMs. I will examine this issue on the basis of a brief summary of a case study about the Ombusperson to the ISIL and Al-Qaida Sanctions Committee of the UN Security Council, one of the most controversial yet remarkable ICMs. It was grudgingly established by the Security Council in 2009 in response to the Qadi judgment of the European Court of Justice. To remind you, the European Court of Justice in that ruling said that it will only implement the resolutions proposing certain sanctions against individuals on the list, on the terrorist list, if it conforms with the EU fundamental rights. And it said at the moment of the decision, the court decided that that the regime did not live up to the minimum requirements imposed by EU fundamental rights. And so the concern of the member states in the Security Council, of the intelligence services, who kind of looking for terrorist suspects and proposed them to be put on the terrorist list, was that the judgment of the ECJ, which prohibited the implementation of the UN Security Council resolution, that this would create a hole in the fishing net, and that kind of terrorist funds and finances could be diverted through Europe. So it created a lot of pressure to act for the member states in the Security Council. And in 2009, they created the Ombudsperson to this sanctions regime. It empowers a single individual. Oh, and what I wanted to show you is, this is Mr. Qadi, who filed the litigation before the European Court of Justice, who also filed a petition with the UN Ombudsperson. And the lady next to him is Kimberly Prost, who was the first Ombudsperson or the first office holder for this institution from 2010 until 2015. Was very influential for this office, and who is now a judge with the International Criminal Court. I will develop my argument in 3 steps. First, I provide a brief overview over the sanctions regime, pointing to its serious accountability and human rights deficits. Second, I outline the institutional shortcomings of the Ombuds mechanism, but also show how the Ombudsperson managed, nevertheless, to become an effective review mechanism. And third, I cautiously draw some broader lessons for ICMs more generally. The ISIL and Al-Qaida sanctions regime establishes a novel form of international security law through which the Security Council exercises international public authority over individuals. In a nutshell, the Security Council targets individuals, places them via the Sanctions Committee, its subsidiary body, on the so-called consolidated list, and requires all UN member states to freeze all listed persons' assets and impose travel bans. These sanctions interfere with the listed individuals' human rights guarantees of property, freedom of movement, personality, and family, and severely affect their daily lives. For example, some of the persons listed on the consolidated list weren't able to receive their salary because they couldn't use their bank account. They weren't able to pay their rent to their landlord. A former rapporteur of the Council of Europe has called the sanctions the equivalent of a civil death penalty. The Security Council initially showed flagrantly little sensitivity for the serious accountability and human rights vacuum it had created. Neither were listed individuals informed or heard in advance, nor were they told the reasons for the listing. Their only legal remedy at the time consisted in the mechanism of diplomatic protection. But while the Security Council has significantly improved the listing regime in incremental steps, the basic legitimacy vacuum inescapably remains. The Sanctions Committee, staffed by international diplomats from the member states represented in the Security Council, is an intergovernmental and power political forum that is institutionally wholly unsuited for designating individuals, let alone adjudicating their delisting application. The institutional solution for this problem was the creation of the Ombusperson, an independent review body tasked with receiving delisting petitions and examining whether the listed petitioner is truly associated with Al-Qaida or ISIL. It conducts its own investigation and makes a recommendation to the Sanctions Committee on whether the petition should be granted or denied. The Ombudsperson is a non-judicial ICM with troubling institutional shortcomings. First, it lacks institutional independence, turning it into a highly fragile institutional arrangement. Second, its process is characterized by a high degree of informality that leaves the petitioner in a vulnerable spot. Third, it lacks the power to issue legally binding judgments, entitling the political bodies responsible for listings, the Sanctions Committee and the Security Council, to override the delisting determinations of the independent review body. If we ended our analysis here, the Ombudsperson would seem like a poor and inadequate complaint mechanism. I want to do a short excursion into the legal technicalities of the legal conditions under which the recommendations of the Ombudsperson prevail or can be overturned by the Sanctions Committee or the Security Council. They are laid down in paragraph 23 of Security Council Resolution 1989, and as I found out in interviews with participants who were, for example, US and German diplomats who were involved in the negotiations, this was one of the most heavily negotiated paragraphs. So, you kind of, also gives you a kind of a sense of the very technical language the Security Council uses. But in a nutshell, I think this is kind of, okay. So kind of at the beginning, the Security Council decides that the requirement for states to take the measures described in paragraph 1, the measures described in paragraph 1 are kind of the sanctions, the freezing of assets, travel bans, that they shall terminate 60 days after the committee completes consideration of a comprehensive report of the Ombudsperson. That's kind of the name of the decision of the Ombudsperson in an individual case, where the Ombudsperson recommends delisting unless the committee decides by consensus before the end of that 60-day period. So this is the first legal avenue to overturn a decision a recommendation of the Ombudsperson, and it's called the reverse consensus rule. So in other words, all 15 members of the Sanctions Committee need to agree or to vote in favor of overturning the recommendation of the Ombudsperson. So it's a very high legal requirement. Kind of the same legal requirement has been put into place within the context of the WTO. And their legal scholars have credited this reverse consensus rule with transforming the WTO settlement system kind of from a more political, diplomatic system into a quasi-legal system. But there's, and kind of this was one of the main reforms, the introduction of this reverse consensus rule in reaction to the Cardi ruling of the European Court of Justice. Initially, there was a consensus rule that required all 15 members of the Sanctions Committee to adopt the delisting recommendation of the Sanctions Committee. So initially, the veto of one single member of the Sanctions Committee would have sufficed to overrule the delisting recommendation of the Ombudsperson, but as a result of the reverse consensus rule, you need now all 15 members to vote to overrule the delisting recommendation of the Ombudsperson. But there's a second avenue, legal avenue, to overturn the recommendation of the Ombudsperson. If we kind of look at the bottom of paragraph 23, it says, provided that in cases where consensus to overturn the decision of the Ombudsperson does not exist, the chair shall, on the request of one committee member, submit the question of whether to delist to the Security Council. And here it's important to look at the precise wording, the question of whether to delist. As you know, the Security Council, in the Security Council, you need 9 members to adopt a vote, but the 5 permanent members, each of them has a veto right. And so if the question on which the Security Council votes is whether to delist, each permanent member of the Security Council effectively retains a veto to overturn the delisting recommendation of the Ombudsperson. So we see that there is, on paper, a very troubling element, especially with the second legal avenue, that an independent review body has been established, but the political body that does the listings, that the review body is tasked with reviewing, can be overturned by this political body. But I suggest that a deeper and empirically grounded look into the practice and institution building of the Ombudsperson reveals that it is a surprisingly effective ICM. Despite the non-binding character of its recommendations, the reverse consensus rule has ensured very high delisting and acceptance rates. Although the Security Council and its Sanctions Committee are legally entitled to overrule the OP's delistings recommendations, they have in fact never done so. The only exception is the Jimali case, in which the Sanctions Committee delisted Jimali from the Al-Qaida list, but instantly placed him on the Somalia and Eritrea sanctions list. There was one other case in which the Sanctions Committee came very close in overruling the recommendation of the Ombudsperson. It's the Al-Faqih case, the case of a Saudi opposition leader who the Saudi government strongly insisted should remain on the list. And so they started a diplomatic campaign trying to persuade other members to vote to overturn the recommendation of the Ombudsperson to delist. And they managed to persuade 12 other member states to overturn the delisting recommendation, including all permanent members. But in the end, Germany, South Africa, and Guatemala voted to uphold the delisting recommendation of the Ombudsperson, and the case was never referred to the Security Council. So the reverse consensus requirement was not met, and Al-Faqih was delisted from the terrorist list. In all completed cases, the Ombudsperson has recommended delisting in 63 out of 86 individual petitions, almost 75%, and in 6 out of 6 entity petitions. What makes these numbers even more impressive is the fact that member states' representatives believe that the vast majority of those names were truly names of individuals who deserved to be on the list. Overall, the Ombudsperson has managed, through politically shrewd institution building, to gain the trust of the member states by accommodating their sensibilities. But she also exploited the break-in points in the legal framework to establish an outcome-oriented model of individual justice that succeeds in getting dozens of petitioners off the list through procedurally efficient and substantively no-nonsense approach. The applicable resolutions only regulate the mandate in broad strokes, and the Ombudsperson, in her own words, filled in a lot of the blanks in the mandate. Let me illustrate this point with one specific example, the standard of review. The central legal standard for listing and delisting decisions is whether a person or entity is associated with Al-Qaida or ISIL. This equally narrow and vague criterion provides the Ombudsperson with little guidance but broad discretion. The political savvy Kimberly Prost utilized the latitude to craft a standard of review that is tailored to the specific context of the sanctions regime to navigate the minefield of Security Council politics. This standard has shaped the office and is meticulously followed by her successors. It requires assessing delisting petitions de novo. This means that the Ombudsperson analyzes the situation not retrospectively by looking into the past at the original listing decision, but by only looking at the present. In other words, it does not review the legality of the original listing decision, but only whether there is a sufficient basis for the listing in the present. This exclusive focus on the present with simultaneous exclusion of the past brings sizable benefits to some actors involved in the process. From the perspective of designating states, de novo review offers a face-saving procedure for false recommendations and no pressure to justify the original listing recommendation. From the Ombudsperson perspective, this approach avoids the numerous minefields that would have been erected with legality review of Security Council listings. The negative effect of de novo review is, however, that it prevents petitioners from challenging the legality of the original listing decisions. This creates a serious justice gap for the petitioner because the unlawfulness of a listing cannot be established and reparations cannot be made. While de novo review looks terrible on paper, I argue that it is a clever legal innovation that has played a critical role in turning the Ombudsperson process into an effective ICM. It disentangles the concern of providing an effective legal remedy to listed persons from the concern of holding the Security Council accountable for the original listing decision. The Ombudsperson succeeds in getting dozens of petitioners from the list without providing a meaningful accountability forum against the Council. This makes it easier for member states to accept the Ombudsperson's interventions. It was carefully tailored to the legal situation of the listed petitioners, most of whom claim to have disassociated themselves from Al-Qaida or ISIL since their original listing. It ties in with the preventative and non-criminal classification of sanctions set forth in the relevant resolutions and takes the Security Council at its word. If the nature of the sanctions is preventative, its existence can only be justified by a persistent threat. But if a person no longer poses a terrorist danger, there is no reason to continue imposing anti-danger sanctions. From the perspective of the petitioner, the advantage of de novo review lies in the fact that new information may be presented and the Ombudsperson's review is not limited by the Security Council's prerogative to assess the original listing decisions. The delisting decision does not hinge on the past. This makes burdensome and fruitless investigations into the Security Council's decision-making superfluous. At the same time, de novo review puts pressure on the member states to continuously update the justification for the listing in the present. This benefits the petitioner if he fails to provide new information. I'll try to explain this by giving you one example. Some member states still assert that, I cite, because we do not have updated information, therefore the grounds for the listing remain. They entirely miss the point of de novo review. Its crux is precisely that the grounds for the listing disappear if the state fails to justify the listing in the present. Critics assert that the purpose of de novo review is to accommodate the prevailing power structures within the sanctions regime, that it legitimizes an otherwise illegitimate sanctions regime. This raises the question whether Prost has developed de novo review in anticipatory obedience to protect the interests of member states, or whether she made the most of the framework set by the Council by cleverly setting the course to benefit the petitioners. While she sacrificed the idea of comprehensive legal review of human rights infringements by abstaining from review of the Security Council's original listing decision, there's much to suggest that she understood that ICMs cannot be developed against powerful member state interests, and that the Security Council would never have accepted legality review of the listing decisions of its Sanctions Committee. The narrative that the Ombudsperson has succeeded through politically shrewd moves in carving out a niche to guarantee basic procedural rights for listed persons is more plausible than the narrative of anticipatory obedience. Where does the case study leave us? On the one hand, the institutional evolution of the Ombudsperson suggests that ICMs have realistic prospects to improve over time, at least if the office holder engages in shrewd institution building and are supported by influential member states, international institutions, and civil society. Institutional constraints can be overcome if office holders skillfully combine statecraft and legal craft and understand that ICMs must defend the normative principles they embody without disregarding core member states' interests. On the other hand, the case study also indicates that states achieve some of the hoped-for effects in terms of cabining the independent review agent. Although many small reform steps have substantially improved the delisting process, more sweeping proposals have not gained much traction. In the Security Council context, for example, cornerstones such as broad political discretion in international security matters and the exclusion of member states' accountability for original listing decisions were not challenged by the Ombudsperson. Hence, the evolution of the Ombudsperson is not only indicative of the potential, but also of the limits of institutional dynamics. What facilitates the institutional dynamics of ICMs? I suggest two possible mutually complementary factors. First, independent dispute resolvers in triadic governance structures wield an influential social role because law critically relies upon and empowers interpretative actors. By virtue of being the triadic entity, they turn into authoritative interpreters of what the normative framework requires. For example, the Ombudsperson concerning principles of procedural fairness and the evidence and level of intensity of association required with Al-Qaida. Moreover, ICM office holders are the actor that is arguably most concerned, most occupied, and most knowledgeable with regard to the dispute settlement system it represents. By contrast, the political and bureaucratic leadership of states has limited attention resources. As a result, they often pay little attention to the nitty-gritty details of the review process that matters a great deal to ICM office holders. These institutional asymmetries put the ICM in a favorable position to create procedural innovations and successfully push for small incremental reform steps. Second, liberal international relations theory on the judicialization of international politics has established that transnational dispute resolution increases the potential for institutional dynamics to unfold by allowing for complaints by individuals. It argues that private actor access helps international courts to generate a mutually reinforcing virtuous circle of steady activity, heightened authority, and growing autonomy from the preferences of states. These claims about the institutional dynamics of transnational dispute settlement seem to apply also to ICMs. In other words, It creates more institutional leverage to expand the quasi or non-judicial role in order to effectively fulfill the demands of the mandate assigned to them. I asked at the beginning of my presentation whether the creation of ICMs signifies a welcome development in international dispute settlement or a lamentable degradation of traditional forms of adjudication. A critique that ICMs are confronted with time and again is that they largely serve as fig leaves to unjust global governance structures. They mask, so the critique goes, that states have little interest in sweeping reforms that restrict their room for action more meaningfully. This critique, however, likely undervalues the various achievements of ICMs. At a bare minimum, ICMs bring some measure of accountability to global governance by providing independent legal review. More consequentially, they provide access, give voice, and provide some relief to some of the world's most vulnerable persons and communities. In the case of the Ombusperson, to Islamic terrorist suspects listed by powerful states to freeze their assets and ban their travel. ICMs can be conceptualized as contact points that bring together individuals and states in a joint procedure on the international plane. It should not be forgotten that such contact points are still much more the exception than the rule in international law. They are islands in the turbulent sea of international relations. Most individuals still do not have any remedy under international law. Instead of pitting judicial and non-judicial mechanisms in international law against each other, the emphasis should be on building islands of effective adjudication, whether judicial or non-judicial. The example of the Ombudsperson shows that there is value in establishing even weak ICMs that are only the second or third best institutional solutions, given the potential of institutions to incrementally expand over time. Even a complaint mechanism that is weak on paper can be a valuable contribution. We may be better off to create extrajudicial complaint mechanisms on the international plane than to do nothing at all. Thank you very much for your attention.
Vielen Dank, Herr Lang. Ich denke, wir machen die Diskussion auf Deutsch, das wird zugänglicher. Das waren sicherlich viele Themen, gerade für die Studierenden, die neu waren. Insofern wäre es, denke ich, auch völlig okay, wenn Sie auch sozusagen Basisfragen stellen zu CADI, zum Sanktionsregime, zur Rechtsetzungsmacht des Sicherheitsrates, was da überhaupt passiert, was ja Voraussetzung ist, das zu verstehen und dann den Korrekturmechanismus sozusagen der Ombudsperson zu verstehen. Fragen, bitte. Ich glaube nicht, dass alle alles verstanden haben, insofern fragen Sie.
Ich hätte Fragen, genau. Andrej, erstmal vielen Dank für den hochinteressanten, spannenden Vortrag. Ich habe viel gelernt. Meine Fragen beziehen sich auf, du hattest erwähnt, dass zunächst es sich einmal um ein, wie du sagtest, fragiles und informelles institutionelles Arrangement handelt bei der Ombudsperson und hast auch an mehreren Stellen betont, dass die Effektivität in dieser Fallstudie vor allen Dingen auch, wie du sagtest, von einem Shrewd Political Institutional Building abhängt. Ob du das vielleicht nochmal ausführen könntest, wollte ich dich bitten. Und dann wäre die andere Frage, und das ist vielleicht ein bisschen provokativ, und ich hatte sie jetzt auf Englisch notiert, ich muss kurz überlegen, inwiefern handelt es sich eigentlich um ein Blueprint, wie du sagst, also um eine Blaupause für andere Ombudspersonen oder andere vergleichbare Beschwerdemechanismen, wenn doch diese Effektivität, wie du sie in dieser Fallstudie beschreibst, doch sehr auch von den persönlichen Eigenschaften und Charakteristiken dieser Amtsinhaberin abhängt?
Ja, das sind gute und berechtigte Fragen. Also vielleicht sozusagen, also was vielleicht der beste Beleg ist für die Fragilität dieses institutionellen Arrangements, sozusagen zeigt sich zum Beispiel im Zusammenhang mit der Unabhängigkeit oder der mangelnden Unabhängigkeit dieser Institution. Zum Beispiel ist es so, dass es lange, also bis vor kurzem musste der Sicherheitsrat immer alle 18 Monate das Mandat der Ombudsperson erneuern. Jetzt wurde das vor kurzem auf 30 Monate verlängert, aber das heißt sozusagen, dass man braucht, jedes ständige Mitglied des Sicherheitsrates hat sozusagen bei jeder Erneuerung die Möglichkeit, einfach sein Veto gegen eine Erneuerung einzulegen und dann gibt es keine Ombudsperson mehr. Das ist ein Beispiel für die Fragilität. Aber auch ist es zum Beispiel so, dass die Ombudsperson institutionell Teil der Peacebuilding Division des UN-Generalsekretariats ist, das den Sicherheitsrat betreut. Und das ist sozusagen die Legal Officerin, die für die Ombudsperson arbeitet und noch also ein Legal Officer und dann gibt es noch als zweites eine Journalistin, die das unterstützt. Die sind beide angestellt von diesem Department of Peacebuilding. Das heißt, sozusagen die Institution, die kontrolliert werden soll, stellt eigentlich die Mitarbeiter dieser Ombudsperson. Und dann ist es so, dass zum Beispiel auch also das eine ist das Mandat der Ombudsperson, das andere ist, die Ombudsperson selbst ist auf einem Beratervertrag angestellt, die teilweise in manchen Phasen nur ein paar Monate lang waren. Das heißt, im Grunde hätte man die Ombudsperson immer einfach den Beratervertrag nicht verlängern können, was sozusagen zeigt, wie provinziell das Arrangement ist, wie völlig unzureichend es wäre, wenn man das jetzt mit zum Beispiel den Garantien für die Unabhängigkeit nationaler Richterinnen und Richter vergleicht. Also das ist ein Beispiel für das hohe Maß an institutioneller Fragilität. Genau, und ich würde sagen, es ist ein Fakt, dass sehr viel von den Persönlichkeiten der Amtsinhaber abhängt. Das eine, die sozusagen Ernennung einer Amtsinhaberin oder eines Amtsinhabers, der sozusagen einfach keinen guten Job macht, kann sozusagen schon auf der Grundlage kann die Institution schon scheitern. Auf der anderen Seite ist es wahrscheinlich in gewisser Weise auch überall bei Institutionen so auch. Ein polnisches Verfassungsgericht kann zum Beispiel politisch gleichgesetzt werden durch die Ernennung von politisch gleichgesinnten Richterinnen und Richter. Also keine Institution ist völlig von der Abhängigkeit von Persönlichkeiten gefeit. Aber ich würde sagen, es ist Ausdruck der Fragilität der Ombudsperson, dass sie in besonderem Maße davon abhängig ist und verletzlich auch.
Inwieweit, Sie haben es ganz am Ende angesprochen, ich würde zustimmen, sozusagen, man sollte das nicht gegeneinander ausspielen, also gerichtlichen Rechtsschutz und durch Ombuds und andere Institutionen, aber inwieweit ist die Einrichtung von einem solchen Mechanismus nicht auch sozusagen das Nicht-Anerkenntnis von Individualrechtsschutz im eigentlichen Sinne? Man windet sich ja so ein bisschen raus, mal etwas flapsig ausgedrückt. Man weiß, dass Individualinteressen und/oder Rechte zur Debatte stehen, aber weil es der Sicherheitsrat ist, bleiben wir bei dem Beispiel, der ohnehin sein politisches Ermessen immer in den Vordergrund stellt und seine Rechtsbindung, die ja auch juristisch sehr umstritten ist, regelmäßig verneint, im engeren Sinne. Er lässt sich ja nicht rechtlich binden. Das ist doch sozusagen vielleicht dann doch eine Alibi-Veranstaltung, sagen wir mal. Jetzt nicht von der Effektivität und vom Ergebnis her, aber in der Konstruktion. Zumal, wenn wir noch einen letzten Satz, der Europäische Gerichtshof ja möglicherweise, je nachdem wie man Kadi interpretiert, eigentlich mehr sehen wollte. Ja, nämlich Rechtsschutz, Individualrechtsschutz tatsächlich.
Also ich stimme Ihnen da grundsätzlich zu. Also ich glaube, also was auch sozusagen spannend war in dem Prozess, diese Ombudsperson zu erforschen, mit Leuten zu sprechen und sozusagen auch selber meine eigene Meinung dazu zu bilden, ist die Institution von einer tiefgreifenden Ambivalenz geprägt. Also in der Literatur war es so, es gab scharfe Kritiker, die gesagt haben, das ist ein Feigenblatt und wäre wahrscheinlich besser, die ganze Ombudsperson abzuschaffen, weil sie irgendwie ein Deckmantel für dieses höchst problematische Sanktionsregime bildet. Und dann gab es die, die gesagt haben, nein, das ist eigentlich eine tolle Einrichtung und es ist eigentlich viel besser geeignet für den Sicherheitsrat als ein Gericht. Und meine eigene Ansicht war von eben so einer tiefgreifenden Ambivalenz geprägt. Das ist einerseits, wenn man sich die Institution anschaut, die Informalität des Prozesses, dass sie eben doch meistens auf Kosten des Beschwerdeführers geht. Also im Fall von der Ombusperson, es gab bisher nur Beschwerdeführer, deswegen kann ich das mich auf Beschwerdeführer beschränken. Also so würde ich es ausdrücken, und es ist klar, dass man sieht auch, wie vorsichtig und geschickt der Security Council diese Institution gebaut hat, damit sie nicht Kerninteressen beeinträchtigt. Aber trotzdem glaube ich, dass es schon erstaunlich ist, dass wenn die meisten Mitgliedstaaten der Überzeugung sind, dass die richtigen Leute auf der Liste sind und dann werden 75% der Leute von der Liste genommen aufgrund der Empfehlungen der Ombudsperson, zeigt, dass es jetzt auch nicht nur Fälle sind, wo es die Mitgliedstaaten eigentlich nicht interessiert und keine Rolle spielt, sondern dass sie durchaus bereits in Kauf genommen haben, dass gewisse wichtige Interessen von ihnen beeinträchtigt wurden durch diese Ombudsperson. Jetzt zum Europäischen Gerichtshof. Ich glaube, ich habe mir auch nochmal die Rechtsprechungsentwicklung des Europäischen Gerichtshofs seit Cadi angeschaut, und Sie haben absolut recht, das ist nicht das, was der Europäische Gerichtshof sich vorgestellt hat. Sogar ganz lustig, es gab sozusagen beim Entstehungsprozess der Ombudsperson gab es einen Konflikt in der US-amerikanischen Ministerialbürokratie darüber, sozusagen ob man so eine Ombudsperson einrichten soll zwischen dem State Department, also dem Äquivalent des Außenministeriums auf der einen Seite, und dem Finanzministerium, Secretary of Finance auf der anderen Seite. Und das Finanzministerium war der Meinung, wir sollten so eine Ombudsperson nicht einrichten. Das schafft nur Probleme und es wird dem Europäischen Gerichtshof sowieso nie reichen. Und sie haben Recht behalten, einerseits, aber auf der anderen Seite ist es jetzt schon so, dass es auch immer wieder Klagen auch gibt gegen das Sanktionsregime vor dem Europäischen Gerichtshof, die sozusagen keine weitreichenden Konsequenzen haben. Also sozusagen stillschweigend hat der Europäische Gerichtshof das doch irgendwie so akzeptiert, wie es ist. Es gab natürlich auch nochmal auf der europäischen Ebene, gibt es da auch nochmal ein Verfahren. Also sozusagen, es gab einige Nachbesserungen, aber sozusagen diese Explosivität, die das ursprünglich hervorgebracht hat, die Unvereinbarkeit des UN-Sanktionsregimes mit dem Unionsrecht, die wurde irgendwie wahrscheinlich doch auch mit Hilfe dieser Ombudsperson beseitigt.